Thank you, everyone. Please be seated. We are here this afternoon for the submission of two cases, and the first one is a state of Kahn and and Hodges versus City of Clermont, Fayette County Conservation Board, and Fayette County, as well as the state of Iowa. Looks like the parties are ready. It's my understanding, of course, Mr. Hixson will cover his base. Who is going to go first for the other side? No, but I heard there's going to be Ian, is it Youngward or Jungward? Jungward, okay. I would have said Youngward, but I will pronounce it, I figure you know. And then Zachary Clausen. So you two can just decide who goes first and also division of your time. I'll leave that up to you. Thank you. Mr. Hixson, you may begin.
May it please the court, counsel. Justices of the Iowa Supreme Court, I'm Russ Hixson. I represent the plaintiffs, the estate of Sharon, Kahn, and Vicki Hodges in this case. As you know, they went over a low-head dam. And when they went over this invisible low-head Clermont dam, they basically got stuck in the invisible hydraulics of that dam. Hydraulics that the state and the defendants were well aware of before this day. Dangerous hydraulics that the state knew would trap an individual in that dam. And that's exactly what happened on this day. These two ladies, mother and daughter, were trapped in this dam, and as the water took them down to the bottom and the hydraulics brought them back into the concrete wall and then up again and down, and it just recirculates. And they struggled and basically just struggled until they drowned to death in what the defendants knew and called before this date a drowning machine. I know that the parties have briefed this very well. The court really knows all the issues. I'd like to focus on the facts because I think the facts in this case and the misfeasance that we allege informs on what the law should be. So in this case, we patterned our petition after publications by the DNR before this date. Publications that basically said a drowning machine is a term used to describe the dangerous situation that's created when water flows over these low-head dams. The recirculating current, known as hydraulics, can take an object, an individual person, to the bottom, and the current brings them back up to the dam. This recirculation can hold even an object, even a boat, indefinitely, and become impossible even for an expert swimmer to get out of. This was a drowning machine. This is a killing machine.
The administrative code indicates that when one of these water trail projects are established, the parties are supposed to enter into an agreement governing responsibility for the project, management of the project. Do we have that in the record? And what does the record reflect on who has responsibility for what?
We don't have that in the record. We were not able to get it. We are not obviously allowed to do any discovery in the case because the case was dismissed on motions to dismiss. We alleged, of course, that all of the individuals installed the warning signs for the dam. We know that many of them had DNR warning labels on them. We know the city had obtained funds.
Let's assume that, I know you're alleging kind of joint responsibility for the project as a whole, but could it matter to the outcome depending on who owns the dam, who has responsibility for signage, et cetera, in that agreement? In other words, is there a fact issue here on that question?
Matter, but it's, as we indicated in our brief, many of these are fact issues. I mean, the court is required to assume all well-pled facts as true and all reasonable inferences, and we didn't know exactly who placed which signs. We know the city of Clermont received funds, undertook the duty to warn of the actual dam itself. We know that initially there was a cable along the dam, before the dam, just like I saw when I came down the interstate and saw the one over the Des Moines River low-head dam with warning signs. And the city had received funds, had put those up, they had a cable, they had the dam warning, and that had come down. And the city had done nothing to replace it.
I take your point with respect to the city, but with regard to the state, why isn't their role somewhat analogous to that of the state of McFarland? In other words, in McFarland, there was another local entity that owned the dredge, maintained the dredge, put up the buoys, and the state's role was basically, well, okay, you know, they in effect own Storm Lake, and why isn't that the role of the state here analogous? Because sort of under the public duty doctrine, you're responsible for your own work, but you're not responsible for how you exercise kind of a government regulatory responsibility with regard to somebody else's work.
We think, and we attempt to show that McFarland is much different. First of all, we point out that McFarland was a close decision. It was a 4-3 decision with Justices Hecht, Appel, and Wiggins saying, no, the public duty doctrine does not apply here. We would hold the defendant liable.
Been on the 3 side, and the majority is the law.
Understand, but the case here is different. In McFarland, there was no allegation that the state had placed the buoys, right? Or that the state was responsible at all once they gave control. And the court said, with control goes liability, right? In this case, we allege the state placed warning signs. They might disagree, but at this point in the litigation, the court has to assume that that's true. The state placed the warning signs. I think this is different also, Your Honor, because in McFarland, the court clearly noted that the danger that was at issue was created after the state had handed over control. In this case, the danger was there when the state knew it was going to designate this as a state water trail.
Question about Chapter 461C. So the state is arguing here that its liability under Chapter 669 extends only to that which a private person could have. And in 461C, it says that private parties are not liable for permitting people on lands basically for recreational opportunities. And so the state's argument, and so there's a liability based on premises and liability based on warnings. If the state's right about that, if the state's argument is correct that a private party couldn't be held responsible for those things, how can the state be held liable here when 669 says that we can only extend liability to what a private party holds?
And I think Your Honor specifically noted the difference. I mean, there is case law where the Supreme Court has said that that section is couched in terms of premises liability. And in the course of Sally versus Stewart, the court noted that, look, it doesn't deal with active negligence. And that's why I wanted to focus on the misfeasance, is that if there is active negligence, then that doesn't apply. One thing
If I may, the failure to warn is set out, though, in 461C. What negligence is at issue here that, for the state, that doesn't go to failure to properly warn?
response would be twofold, Your Honor. First of all, I think the negligence is the state included a drowning machine in a water trail that it promoted to the public. It created a situation where it says this is safe. It cleared land for parking lots. Our people used those very parking lots. It constructed those. It created signs and warnings for people that would use the state designated water trail. So I know the defendants would focus just on the dam. Our focus is you can't intentionally place a drowning machine in a state designated water trail and then not have a duty to warn the public that they could be killed if they go over that drowning machine. Now, one thing that I noted in looking at the very chapter you're talking about, in looking at the defendant's arguments, is the fact that the state then goes on in 461C to define what a holder of property is. And it's not in their brief, and I apologize, I missed it, but the definition clearly says a holder means possessor in fee interest, tenant, lessee. Holder shall not mean the state of Iowa, its political subdivisions, or any political body or agency, departments, boards, or commissions thereof. the legislature was keenly aware of the issue, and they said, we're not going to include the state of Iowa. And they specifically said land includes land that is not open to the general public. By basically saying, hey, you can bootstrap in sovereign immunity, don't you go directly against the legislature's specific definition of what a holder of property would be. So we submit that they can't claim no liability under this section when the legislature specifically, as opposed to the general, and we always read the specific to control over the general in statutory construction. Our argument is you can't allow them to bootstrap in sovereign immunity when the legislature says this section does not apply to you. Did I answer your question, Your Honor? So we see the actions in this case very specific. The facts are, if you look at misfeasance, the state and the defendants cleared property. They created a water trail knowing that there was a drowning machine. They then invited people to that drowning machine. They undertook the duty to warn by placing warnings. Now we allege, as the court must assume, those warnings were not placed.
Actually, how far up the river were the first warning signs, and were they still within the city limits of Clermont?
I can't answer your question on whether or not they were within the city limits of Clermont. I do not believe that they were. The best we can tell based on the warning signs is the first one comes into play after the last exit, meaning when they could have gotten out. The first warning comes, and it's by a sign. And I think, if my recollection is, it said 2,000 feet to dam. The problem is, and my people would have floated right by that sign. It was about this high, right on the bank, and the grass was that high too. We have pictures the day after, you can't see the sign. The next signs that come up that are mandated by the state-adopted warning manual were down the river, and they were on the banks, but yet trees and brush were growing over them. You couldn't see them. We have pictures of them. We have pictures of the brush piles and the places where they went in and cut tree branches this big to get rid of the trees that were growing over those warning signs. If you cover existing warning signs, isn't it the same as not having any warning at all? And they knew they were required to have warnings. Getting back to your question about control, the state never gave up control over designation of that state water trail. At any time, the state could have said, this is not being adequately warned. We're going to take it off the state designation of a water trail.
Regulatory control. Having the ability to regulate something really isn't enough under the public duty doctrine.
But control is under McFarland. I mean, they're the ones that designated it as a state water trail, knowing it had a drowning hazard. So are we going to say they have that power, but if they undertake the duty to warn and the public's at issue?
The state could have shut down the dredge too. I mean, the state is kind of all powerful in Iowa. But the real question is it something the state, I mean, if the state put up the signs, that might be a different issue. But if the state had no role in the warnings, the dam wasn't the property of the state, the Portage Trail wasn't the property of the state, the fact that they just designated it a water trail, that strikes me as you're in public duty territory.
But we allege the state put up signs, which the court has to assume to be true. And so, and we allege the state specifically made a DNR water trail crew to help maintain the water trails. So as far as we know, until we get into the facts of the case, the state had an ongoing obligation to help take care of these water trails. As the county said in their brief, this was a partnership with the state. The state didn't just hand it over like they did in McFarland. Even the county recommends they were in partnership with the state in creating and maintaining these water trails. I agree. If this were a case on motion for summary judgment and we had the facts, and the facts are as indicated by Your Honor, then yes, it may be a motion for summary judgment based on the public duty doctrine. But this is a motion to dismiss before we even get to discovery and are able to delineate who has the obligations and how are they separated between the parties. We believe this is more like the cases of Breeze and Fulps and Estate of Farrell, where the court says, once you undertake a duty to warn of a danger that you help create, then you have an obligation. Breeze specifically talked about the Summer case with the golf course and said, when you develop, design, and undertake warnings, you have an obligation to complete those. I see my time's up. Thank you.
Board.
May it please the court, counsel. My name is Ian Jungward, here on behalf of the state today. Your Honors, this case squarely falls in within this court's decision in McFarland, where this court emphasized that liability follows control. And here, the state had none. The plaintiffs don't allege that the state owned, operated, or maintained the dam. Instead, their theory hinges on the state's role in providing funding to local entities for purposes of managing the water trail and the dam. But providing financial support does not equate to assuming legal responsibility. The allegations amount to a claim that the state failed to ensure these local entities complied with the safety regulations it had set, precisely the type of claim that the public duty doctrine precludes.
Doctrine be avoided if the state had put in warning signs upriver from the dam, as alleged.
I would argue that it wouldn't. In McFarland, you had the state there who had sufficient control. It had control over other buoys that.
It didn't install the buoys along the dredge pipe that was submerged, did it?
Not specifically for the dredge pipe. But here the plaintiff's petition alleges that the defendants at a whole had some duty in placing, or had some role in placing the warning signs. However, if you look at the petition as a whole, you'll see that the state's duty in allegations 24, 25, 52, 53, 54, 55, they all talk about the state's duty as one that sets regulations and criteria for placement and maintenance of these signs, and talks about how the state's role in this is to provide funds. And that conclusion is supported by the Administrative Code, Chapter 30, which talks about the state's role in providing funds under the Water Trails Program and under the Low Head Dam Program, where as a part of those programs, these local entities that have applied for the funds were responsible for ensuring that the dam was modified in a safe manner. And it specifically recognizes that warning signage of dams is part of these programs.
57, prior to 6/8/20, defendant State of Iowa, defendant Fayette County, defendant and/or defendant City of Clermont placed dam hazard warning signage upstream from the Clermont Dam. So they've alleged that your client was involved in doing the signage, which seems to me takes it out of McFarland maybe.
They allege that they were involved in some capacity, but as I mentioned before, if you look at these other allegations within the petition, it gives color to what the state's role was in the placement of these signs. And that role was that they provided funds to local entities that were responsible for them ultimately.
Both. I mean, you sort of pled in the alternative, which I think you're entitled to do if you have a good faith basis. They've said state was a regulator, state was a promoter, state was a funder, but state also was responsible for some of the actual, work that went into at least designing the warnings and implementing the warnings for the dam.
Your Honor. I would also like to point out that these decisions by the state would likely fall under discretionary function immunity. Specifically point the court's attention to Shelton v. State, a 2001 case that this court considered where the defendant or the plaintiff there was suing because he had been hiking on state-owned trails and he was suing the state for negligently maintaining those trails. In that case, the court found that the substances used in forming the trails, the placement or omission of warning signs, trail maintenance, were all matters for park professionals that were covered under the discretionary immunity doctrine.
It seems to me the argument is that the state already decided to put up warning signs. Did the state decide that it was not going to need warning signs anymore? It seems that the sort of choice was made earlier, and the state was just negligent in making sure that those signs could then be seen.
Well, I think that's the case here is directly on point with what the public duty doctrine is meant to preclude, which is that the state has a duty to enforce compliance by third parties with its safety regulations. And that's exactly the case that we have here. You have
Shelton to sort of mean that the state could choose whether it needed to put up warning signs or not, but once it actually decided, then the warning signs sort of needed to stay up, or they were negligent if they couldn't be seen. Do you read Shelton differently?
Yes, Your Honor. I think that these are all decisions that involve some sort of policy-based judgments, which that's also the case here. You have in the Chapter 30 of the Administrative Code, all of these different judgments that the state considers when making its criteria. They involve decisions, or they involve considering aesthetics of the park, financial resources.
So I understand, are you suggesting that the state could have discretion whether to put a warning sign up, but once it chose to put a warning sign up, it could have discretion to let that become blocked by grass or trees?
Under how these programs operate, and so it does have discretion where it's going to allocate its resources in maintaining these water trails.
A summary judgment argument to me. I mean, if they've alleged that, your client put up the signs and then allowed them, bushes to become grown in front of them, and they weren't visible, 4 of the 5 weren't visible, doesn't that get you past the motion to dismiss?
Your Honor, again, I would argue that what they are alleging here is that the state had a role in this. But then when you look at the petition as a whole, that their role was clearly confined to funding.
If the state had actually went along and pulled the signs, kind of like an outward saying, we don't think it's necessary anymore, but to let them get dilapidated or have vegetation grow around it, isn't that completely different?
Your Honor, I'm not sure if I understand the point you're making.
And once you put those signs up, a duty to maintain, or if you don't think it's necessary anymore, wouldn't that be more appropriately evidenced by pulling the signs instead of just letting them go? I'm just saying I think that would be a better argument for you than the way the facts are in this case.
Your Honor. And I see that we are halfway up. Yeah.
That it is not protected by Iowa Code Chapter 461C. 2, given the definition of holder that excludes the state?
I would not concede that, Your Honor. And 461 contemplates our argument as it pertains to private individuals is is that private individuals would not be liable here where they're opening their land for public use and recreation.
Argument raised in the district court.
The overarching argument was raised, specifically citing to that provision of the code was not raised, but
Its argument in the district court, it was a private person couldn't be held liable because only the state holds waters in public trust and no one else does. I didn't see any reference to this 461C kind of incorporation argument.
you're correct, Your Honor. There was no explicit reference to that. But I would point you to the case of Ames 2034 versus City of Ames, where the Court of Appeals cited JBS Swift versus Ochoa, and in that decision by this court, they recognized that that's additional ammunition for the same overall argument, which is not a new argument advanced on appeal. Yes, I want to be respectful of my fellow counsel's time, so I see the rest of my time to him. Thank you.
May it please the court, counsel. The Iowa legislature has made a policy determination that municipalities in this state are immune from claims arising out of recreational activities that occur on public property. Before diving into the issue of recreational immunity, I want to point out something specific as to the city in this case. If you look at the district court order ruling on the city's motion, it was granted for the reasons stated in the city's brief in support of the motion for judgment on the pleadings. One of the primary arguments raised in that brief was recreational immunity. Because the plaintiffs failed to meaningfully address that in their opening brief, we urge that that issue is waived on appeal and that the judgment of the district court.
That order to say that, didn't the judge, I mean, I think the order was written in a way that maybe is subject to more than one form of interpretation. But she said, let me see here. Yes, it was a she. I've got it right here. She said that for the reasons outlined in the written arguments of defendant, the board, conservation board, and defendant so-and-so, this court finds a dismissal of counts 9 and 10 is appropriate due to the applicability of the public blah, blah. For the reasons stated in the defendant's city of brief in support of its motion, the court finds that it's properly granted for the same reasons. Do they mean same reasons of the brief, or do they mean they're granting it for the same reasons as they did for the board of conservation? I don't think it's clear.
The order could have been better written. We interpret that to say, for the reasons stated in the defendant's city's brief, it is granted for those same reasons.
Former trial judge, I think the way she wrote it, I might be guilty of saying the same thing. I wouldn't be proud of it, but granted for the same reasons. I'm granting it for the same reasons I just granted something else.
This court doesn't find that the issue is waived. We urge that the city is still entitled to recreational immunity under the plain language of the facts in the petition. What the petition indicates,
Dam.
Your Honor, the city has denied the dam in the answer, but for purposes of this appeal, assuming the allegations as true, yes, we're deemed to have owned the dam for purposes of this appeal. In terms
Allege.
that the city owns the dam. In terms of recreational immunity, the petition admits that the decedents were river tubing, and I quote, that river tubing is a recreational activity wherein an individual floats on an inner tube and allows a river's current to carry the rider downstream. This is exactly the type of situation for which the legislature granted broad immunities to cities to promote recreation and limit liability.
Isn't there some question about what you sort of sign up for when you go tubing? I mean, there's a risk that there might be sharp rocks at the bottom of the river, or there might be trees in the river, or there might be fishing line that you can get caught up on. But the fact that you might go over a dam and drown, I mean, isn't that a little different?
The risk in this case is death due to drowning. By its very nature, drowning is an expected risk of river tubing down a river.
Machine involved.
Even if the drowning itself is not enough, at all relevant times, the Turkey River overtopped the Clermont Dam. And so encountering
Normal and expected risks inherent in the recreational activity. And then whether, you know, the plaintiffs knew or should have known that the recreational activity created a substantial risk of injuries or damages. That sounds like quintessential fact issue stuff in this situation. I mean, I tend to agree with Justice McDermott. It's one thing if they had hit a rock or something, but going over a dam.
Your Honor, our position is that at all relevant times, this river water trail overtopped the Clermont Dam. The recreational activity is tubing down the Turkey River Trail, and the dam was always present.
There you say, well, this recreational activity has this risk, and therefore it's a normal and expected risk associated with that activity. I mean, that's kind of circular, right?
Stronger argument if you had big old signs all over the place warning people, but then we're back to that argument as well.
Petition concedes that at least one of the signs were visible leading up to the dam. I believe that the court can determine as a matter of law that the decedents knew or should have known of the danger of the approaching dam.
The defendants concede that one warning sign was not enough, so I don't think you can rely too much on that petition, can you? Don't you need to read the whole petition?
You do, Your Honor, but one thing I want to point out, based on the other arguments so far, is that if you look in detail in the petition and the signage requirements, which come from Justice McDonald's questioning, is the state and the county are the ones who are alleged to be the partner in this river trail project. As it relates to the city itself, the only allegation of the city is nonfeasance for ownership of the dam, for failure to upgrade the dam. I see that I'm over time here. We'd urge that.
Around longer if we need to.
By that last point, so, and I need to reread the petition, obviously, but are you saying that if you read the petition as a whole, the city of Clermont is not indicated to be a partner kind of in establishing, maintaining, operating the river trail?
I believe there is a paragraph, I can't point it to you off the top of my head, but it says that the state and county were involved in developing the Turkey River Water Trail. The city's role is as the alleged owner of the dam itself. For those reasons and those outlined in our brief, we would urge that you affirm the judgment of the district court as to the city. Thank you.
Mr. Hixson.
I want to first address the sign issue. As we allege in starting at paragraph 49, as part of the dual water trail low head dam programs, defendant state of Iowa developed standards for low head dam warning signage. 50, at all relevant times, state designated water trails, including the Turkey River Water Trail, were required by defendant state of Iowa to have low head dam warning signage installed and maintained consistent with the standards developed by the defendant state of Iowa. I know they argue that this was a discretionary function, but that discretion had already been exercised. They decided to place warning signs. In fact, they decided exactly how warning signs needed to be placed, where they needed to be placed, what kind. Their manual is even specific of saying how big your lettering has to be based on how far it is away for people to see it. You're talking about tubers floating down, looking up on a river. And so these standards are very important. The fact is they adopted those standards. They mandated that they be complied with before opening the Turkey River Water Trail up as a state designated water trail.
To that last question of the county, is the city part under the ordinance, is the city part of that responsibility, or is that a state and county partnership?
The way we understand, Your Honor, and the way we pled it, is that the Turkey River Water Trail was a water trail between the state and the county. But then they then gave funds to the city because the city owned the dam. So the city had the obligation and undertook the obligation to place warnings at the dam, to put warnings across the dam. Some of the warning signs, the ones that were grown over and you couldn't see, were placed on city property. There's a city park right there, and it was placed on the city's property, so I assume the city placed those. The portage that was mandated to be available and properly marked was totally grown over. You couldn't see, so even if somebody was aware of the danger.
Also on city property.
The portage was on city property. The city had undertaken obligations to warn of where that portage was. Even if our people knew you have to get out, there was no way for them to know where. Where do we have to go? Which direction do we have to move? For example, the city is required, they're mandated under their, the money that they received to put warnings on each side of their dam. One side doesn't have a warning at all. If somebody is coming down on that side, floating down on that side, there's no warning, but it's mandated that it be there. And so the city is obligated for that. We may get into it, Your Honors, and they may say, hey, this was kind of a joint thing. The state and the county, we're going to kind of do upstream, but we've made an intentional decision to include your dam. And so we're going to give you money. You're going to warn of the dam. You're going to put the warnings on your property. You're going to be responsible for the portage. That we'll know a little bit more after we get into discovery and find out exactly how it was delineated. But they were clearly received money, and they clearly undertook a duty to warn. It's no different than the voluntary undertaking doctrine that we talk about in our brief, that if you have voluntarily undertaken a duty, especially a duty to warn for third parties, to protect third parties, and you don't do that, then you're obligated. Well, this wasn't just a voluntary undertaking that was gratuitous. They received money to do it.
Recreational immunity argument and whether or not we can decide as a matter of law, kind of going over a dam in the state of Iowa on some of these rivers is normal and expected risk.
As we argued, Your Honor, it is a factual issue. Now, I don't know that this court is willing to say that a low-head dam is, as a matter of law, something that people know about. We cited cases right on point with low-head dams where the court specifically said, these are dangerous hydraulics. You can't see them. In fact, you can't see this dam upstream at all. How is this known and obvious? And more importantly, if it's a 5-foot high dam, that's how big the concrete wall was, and the water takes up part of that, it may not look dangerous at all, but courts have said, the Volpe court specifically said, the dangers of these hydraulics that will basically take you and pound you against the wall until you've drowned, they're not known to anybody. And in this case, you have to show not only that it was a normal risk of tubing. Well, that means every parent that takes their kid out knows that there is a substantial risk. It's not just a risk. It has to be substantial and that you know you could die. That was not the case here. Thank you.
The case of Estate of Kahn and Hodges is hereby submitted. And we'll just pause for a moment while the next attorneys get ready for State versus Scullark. Looks like the parties are ready. Mr. Howe.
May it please the court, counsel. Not all searches incident to arrest are the same, and the Court of Appeals erred when it flattened these distinctions and applied the inapposite Gant and Gaskin's search incident to arrest exception to this Robinson search. This court should correct their mistake, vacate their opinion, and affirm the district court. I'd just like to start at the 20,000-foot view for this instance and talk about the 3 different contexts for search incident to arrest. Initially announced in Kymel, but we'll come back to that in a moment. I want to start on basically scopes coming out. When we're talking about the arrest of a person and items that are immediately associated with their person, their clothing, their jackets, containers within those containers attached to their bodies, those searches require no justification. They are reasonable as a result of the arrest. Your Honor, do you have a question?
That reminds me, one of the questions I wanted to ask right out of the chute was, Blue Brief says that this case is identical to the unconstitutional search in Gaskins, and that was actually the point I wanted to make. You tell me, what do you think are the distinctions other than in Gaskins, the gun was in a glove box, I remember, if I'm correct. And in this situation, it was outside the car after the defendant knew that what was going on and handed off something. So help me understand, is this identical or not? And if not, how are they different?
They are not identical in any way. Gaskins was a case involving a search incident to arrest beginning in an automobile. In this case, Your Honor, the video depicts how Officer Bolstad encountered Mr. Scullark outside of a house. He was sitting on the truck, but he wasn't pulled over. He was just sitting there. The officer arrived there independently. And when he announced, hey, we need to talk about this domestic, I'm intending to arrest you, Mr. Scullark bolts into the residence over the officer's objections. And once there's a quite emotional confrontation in which he insists he can't go back to either prison or jail, but he can't be incarcerated. He hasn't done anything wrong. At this point, Officer Bolstad is alone with Mr. Scullark and two of his associates who are trying to comfort him, but he's quite distraught. The two cases are not the same. And returning to my line of discussion, Kymel is the second exception to the search incident to arrest. And in that instance, that is what authorizes officers to search the immediate area around a arrestee. That's talking about a desk, drawers in a desk. It talks about, I would say, the space immediately around them. And then the third one is the automobile exception discussed in Gaskins as well as Gant. And I think it's fair to say, I don't mean to take up too much time on this because I don't think it's at all applicable, but Gant is a reaction to Belton as discussed in Thornton. It's a expansion and then a contraction of this third context, the search incident to arrest involving vehicles, which again is distinct from the one we're talking about here.
If you wanted to make an automobile analogy to this case, I think I wrote an opinion for the court in Rincon a few years ago where there was, the law enforcement had the right and authority to search the vehicle, and this person gets out with her backpack as if that would somehow insulate the backpack from search. And we said, no, that doesn't work. And this is the same thing, kind of thing.
Reasonable searches shouldn't turn on games of hot potato in which a defendant or arrestee is able to quickly enough move the bag away from their person. Rincon was correctly decided.
In Gant, I think the general principle established for the exception was officer safety or to find evidence that relates to the arrest that the officer is conducting. In this case, I don't think that there was anything, starting with that second point, that there was anything that they were looking for relating to the domestic assault that was in that fanny pack. And by the time the officer looked inside, Mr. Scullark was already handcuffed and he was about to enter the squad car. And so I struggle to see any public safety rationale. And so if we were to look at this in the same view as Gant, would this fail?
To start from the top, I think your example demonstrates why the three categories function the way they do and why this is not a Gant and a Gaskins search. In no other context of this trifecta, for Robinson searches or Kymel searches, is the ability to search for evidence a rationale under supporting it. It's only in the automobile context that applies. So to come back to your question, do I think it's possible that a search of this fanny pack could have revealed evidence relevant to the domestic abuse allegation? I think it's possible if we had documentation proving up his residence, if there was the watch that was alleged to have been thrown at the individual. It's possible we could have obtained that evidence. But again, we're talking about separate interests justified by each of the contexts. And here, when we're talking about an arrest of an individual in a highly charged environment, that's when the Robinson version of it makes the most sense, where there is a danger to not only the officer, but the people in the immediate area, that if the arrest goes sideways, something violent could occur. And as Riley recognized, any physical object in this context is possibly dangerous. And so the search is categorically reasonable. We don't need to establish an independent objective purpose for it. Now, to play out your other, oh, sorry, please go ahead.
He didn't possess it at that point, right? Scullark didn't actually have it. And so what was the danger that would have arisen based upon, I think her name was Tina's holding of this fanny pack?
So I think it's a little bit favorable to assume that everybody present with Mr. Scullark had the state's best interests in mind. So let's say that, I believe, not to actually you, but I believe her name is Tammy. No, you're fine. When Tammy takes the bag, any number of things aside from her holding it for a moment until the officer directs her to drop it could have happened. If there had been a weapon inside of it, she could have seized it and used it on the officer. That's why the seizure is immediately reasonable. That's why the search of it is immediately reasonable. Now, I think your question is getting at possibly how the Knapp and the 10th Circuit addressed the question, which is that we should examine these in the second Kymel context as the time of the search to make sure that the justifications for the search are actually being served. But even then, those interests are still being served here. Again, we are talking about officer safety in the context of a dramatic arrest. And I will say, you're correct. He's not inside the vehicle he's about to be. But I also think he's within the immediate reach. And it's not in the record, of course, but even 10 minutes of Googling will demonstrate that there are numerous instances in which handcuffed individuals obtain weapons and assault the officer arresting them. There was at least 2 in 2020 and 2022. There was 1 in Maine in 2024. These are not impossible events, and the interests of the search incident to arrest exception, even under a time of search analysis, those interests are served here. I would also just like to talk about how the majority has introduced instability into our law by jettisoning its previously decided cases. I think some of them might need to be recontextualized after Rowley to make sure that we're being consistent in the context we're applying, but all of them were lawful under either the Robinson or the Kymel formulation. For example, in Hershey, it was a purse that the individual was holding when confronted by the officer, and the officer physically took it from her to search for a shoplifting incident. That would be a classic Robinson situation where the arrest is going on and the purse is immediately attached, actually possessed by her at the time of the search. Turning to the cases specifically relied on by the district court here, there's Saxton, Allen, Jones, Shibut, and all of these are various iterations of either something actually possessed by the individual at the time the arrest is about to occur. In Shibut, she was about to cast it off and then re-grabbed it, or instances in which it was within the individual's reach at the time of the arrest. And that's the rule for the second context, the Kymel exception that the state's urging for here. When we're talking about a search, if we're going to talk about what is reasonable inside the immediate area, we should determine that rule from the moment the arrest is announced and effected. Otherwise, we are encouraging games of hot potato. We are encouraging people casting things off to Confederates or family members.
When did the officer announce that he was under arrest? Was it in the house?
Gosh, certainly it was repeated in the house. It might have been announced at the truck, and that's what caused him to go inside.
Handing the fanny pack to Tammy.
Announced that he was going to be going. That's when Mr. Scullark handed off the fanny pack to his friend.
Arrest at that point. Okay.
The intent, he's
ready as the fanny pack is being handed off.
realizes what is in that bag is going to accompany him back to the police station. It becomes paramount that he gets it off his person. And that's another reason why if we're doing the second Kymel version, we should be looking at the time of the arrest, because even if the interests are somewhat minimized, are lowered at the time of the search, if the individual is handcuffed, it's still consistent with the purposes underlying the entirety of the exception to ensure that officers are safe, that we are not permitting people to subvert the arrest. I also just would like to note that this is just a search consistent with common sense. We shouldn't be asking our officers to acquiesce in events that would result in their harm. It's contrary to common sense. It's contrary to our law. And I would just briefly finally like to talk a little bit about 814.6 sub 3 while I have the court's attention. I don't think it was necessary to gloss the statute in this case. I would be forthright and say that the state waived the matter. We do not believe that this is an instance in which the court lacks jurisdiction, but I don't think we need to define a statute in the absence of adversarial briefing. Those cases, I assure you, will come. One is to be submitted next month, State v. McLean.
There could be a situation where the state agrees below that a conditional guilty plea can be taken in order so that the defendant may have the appellate court consider a matter, and then it gets up on appeal and the state feels, no, there is no jurisdiction, they can change their mind?
Provide a little more context to my last statement and to answer your question, Justice Mansfield, there will be instances in which the parties agree that a certain claim should be presented to the appellate courts for adjudication, and somewhere between the district court and the blue brief, something changes. And if that issue is not consistent with the rules of criminal procedure, not consistent with 814.6 sub 3, at that time, yes, the state will cry foul and point out the error and the lack of jurisdiction.
This case?
To be quite clear, Justice Waterman, that's part of the reason for the awkwardness of the state's position here on further review, but I wanted to be candid with the court. We're not objecting to it here, but we don't need to define the statute when we don't need to. Justice May, please.
Of what you're saying then that would be permissible, is it any different than an error preservation analysis?
Very similar, especially because when we're talking in 814.6 sub 3 about reserving an issue, I think to reserve an issue, you had to actually present it, you had to actually provide some specificity. It would need to be timely. We would need a decision, and I believe you would need to have requested an appropriate remedy. I think this court, more often than we might care to admit, sees requests for remedies that just are impossible to grant, and that might be another reason why it would not be in the interests of justice, because if there's no possibility of granting the remedy that's requested, reserved or not, it's not a good use of appellate resources. And I think the way the statute is written, it reserves to this court the ability to determine when those criteria are met. For the foregoing reasons, because this was a lawful Robinson search or even a lawful Kymel search, the Court of Appeals erred in applying this court's past announcements in Shane and its own past precedent. It misapplied the Fourth Amendment as described by the United States Supreme Court, and it frankly defined a statute that didn't need definition quite yet. I will speak to you again on rebuttal.
Thank you. And Mr. Irwin.
Thank you, Your Honor. May it please the court, counsel. I'd like to begin by just a point of clarity. There is no such thing as an independent search incident to arrest of a vehicle doctrine. The state has advocated there are 3 categories of search incident to arrest. That's incorrect. There are 2. There are search incident to arrest of the person and immediately associated items. There are searches incident to arrest of other items. Your Honor?
Limited to cars?
Because Gaskins correctly applied search incident to arrest principles as announced. Frankly, in Gantt, I think there was some confusion at the time of Gaskins exactly what, and it remains to some extent today, exactly what the federal position was on Gantt. And so said, look, we'll just bypass all of that. Under Iowa, it's not a valid search incident to arrest if the person can't reach the object. If it's in a car, if it's anywhere else, it's totally irrelevant.
Counsel, is the state just wrong to put so much reliance on Robinson in this case?
Yes, Your Honor, but for a different reason. The state is incorrect to put so much reliance on Robinson because this was not a search of Mr. Scullark's person. This was a search of a container which Mr. Scullark did not want to bring with him. The officer insisted he bring with him.
This is a practical matter because I feel like what is being advocated sort of for the defense is that the police officer, by being sort of patient and letting him get rid of the fanny pack, the state sort of put themselves in a worse position from an evidentiary point of view than if the cop would have just I don't know, tackled him from the very beginning of the arrest, and then he'd have the fanny pack and the person, and that would be super dangerous for everybody, and everybody agrees that wouldn't have been the best way to approach it, I assume.
Yes, Your Honor, and I would say that most of what the officer in this case did was perfectly acceptable. I understand he was faced with a contentious situation. He was outnumbered at the beginning. He was absolutely within his rights to order the third party put that down. The problem is he is not within his rights to say, I'm taking that because it was with you, we're searching it, period, we're done.
Again, to get the fanny pack, he needed to just go and grab the fanny pack and not let him give it away.
Yes, Your Honor, although I would also note, and this gets to some of these sort of gamesmanship concerns that the state points to, it is not reasonable for an officer to intentionally place themselves in danger to ensure that they can search something. Justice Scalia talked about that in his Thornton concurrence. And I think that is, the danger in this case comes from the fact that the officer insisted on bringing that pack with him, even though Scullark didn't want it.
This out. So, Mr. Irwin, you can see that he could have told the woman who was there, put that down and leave it, and then he could have gone and gotten a warrant later to look at it.
Had any probable cause. The problem here is there's no probable cause whatsoever to search that fanny pack.
Yeah, well, we don't know. But let me just finish, if I could. So then, what if the person said no and started walking away?
Then the officer, well, first that person will have at that point likely committed interference with official acts, so they're probably subject to arrest. But even if they hadn't, Terry principles address all of the third-party concerns the state is talking about. Search incident to arrest has nothing to do with third parties. That's once we're talking about the danger a third party might pose, we are out of search incident to arrest territory, and we are potentially in Terry territory. Sorry, yes, Your Honor.
What about the argument that this fanny pack could have had evidence of this crime, that it may have had the watch in it that hit her, may have had a driver's license in it, may have had something that would have helped with this, the investigation of this crime?
Yes, Your Honor. Regarding the watch, exactly where escapes me. I feel there's something in the record indicating the watch stayed at the scene. I'm sorry, I couldn't point exactly where in the record, but I don't think there was any belief that the watch was in that bag. As far as identification, it's tricky because, of course, that would only be relevant if they were going forward with a prosecution for domestic assault, and it's somewhat unclear. I know the officer referred to it that way, but then the complaint filed, if I recall correctly, is normal assault, and he was never charged with that. And so perhaps if it were a domestic abuse case, it's unclear to me that it is based on the record that we have.
Ask him if he had lived with the complaining witness. He said, yeah, he did. So it seems like that was what the officer was looking for.
Asking that question? Yeah, I agree. Yes, the officer was doing some investigation by asking that question, but it's completely different than the entitlement the officer displayed to just open and search this container simply because Scullark had it, but was trying not to possess it at the time he was arrested.
I understand your argument. So you're not contesting the authority to conduct a search of the person and anything on their person at the time of arrest, correct?
At the time of search, Your Honor. The distinction is, I think that people are free to put an object down at the time of arrest, and police cannot do anything about that, barring Terry implications, probable cause to seize the item. My main argument is the officer was not entitled to not allow Scullark to put the bag down.
The rationale for that. So the Supreme Court has said that if you search a person incident to arrest, there doesn't have to be any reason to search any containers on their person. It's just justified by the fact of arrest. So why does the person dropping a bag on the ground or wherever he put it in this case, I think he set it on something and then the woman grabbed it, why does that change the rationale underlying the search incident to arrest doctrine? I guess I don't understand that.
No longer part of his person, Your Honor. It's not his clothing, it's not containers within.
than the cop, but because he can sense the cop's going to arrest him, that doesn't, I can just imagine all the shenanigans that are going to happen. As soon as they sense arrest, boom, drop it, and then it's off limits.
If there is no grounds for the officer to seize or search the item,
Imagining, I haven't said anything till now, but domestic abuse, I can think of lots of ways that something in there might be relevant. And I think the questions he's asking, oftentimes somebody gets charged with one offense, but by the time it gets to the indictable trial information, it's changed a bit because they've learned more. So it could be morphing from assault to domestic based on what they find. Let's say she says he has a silver little ring that whenever he takes that out, that's a word for me to behave, or I'm going to get it. And then all of a sudden, that's in the bag, for example. I'm making that up from an old case I remember. It was a symbol for her. So if later on she tells him, you know what, he carries a silver ring with him, whatever. There's just an example where, damn, that just supported what the cop was saying. So I am not so dismissive of there would be nothing in there that's relevant.
Your Honor, I understand, and I think that those justifications are to some extent why searches of the person don't have to get into this question, whether they may.
Just because he's quick enough to drop it, it no longer becomes the person, even though it's within 6 inches of him?
It's his property. He is entitled to do with it as he please if the police do not have any valid reason to. If it's on his person when he's being arrested. I think, and I know that the cases discuss the fact that a search of the person is justified just merely by the fact of arrest. I think there's more underlying it than that. Specifically, their person is going to come with them in the car. You need to make sure they don't have something in their pocket, in their bag, that they could harm an officer with or destroy. But when we're talking about a container which the person does not want to bring with them,
Hey.
Your Honor, but I think it's sheer speculation. I mean, of course we know what was in the bag after the fact.
Now, I mean, I'm just looking at Riley, isn't part of the rationale that there may be evidence on the defendant's person, and you don't want that evidence to disappear?
Of the offense of arrest. I think where things are going awry here is the state wants searches which find extras, right?
On the video, he's handing his cell phone and the fanny pack. The cell phone almost certainly has evidence that would be relevant. Now, you'd need to get a warrant to look at it, but you wouldn't want it to disappear, right?
It's the same thing. He's entitled to do whatever he wants with his cell phone until we reach the point where the state is entitled to seize it.
Assume that he's wearing his fanny pack, he's been cuffed with his hands behind his back, and that as he's walking to the police car, he's able to unhook the clasp on the back of the fanny pack. Assume I did not own a fanny pack when I was in junior high and know that there's a clasp. Assume that he's able to unhook it and it drops. Can the police pick it up and search it at that point?
No, because it's not on his person at the time of search. I know it seems like
Kept it on. If he hadn't taken it off, then it could be searched. So he decides what the officer can search while he's being arrested.
To some extent, yes, I think that's true. That's always true. The people decide if they.
Or takes it off. So the officer arrests him and then takes off the fanny pack to get him in the car. Can he now not search it because it's no longer on his person?
More difficult question when the item is removed immediately prior to search. I acknowledge that. That's more like the cigarette pack in Robinson, things like that. But when there is a significant break in time between the object not being available to the person and the officer searching it, let alone the person not wanting to bring that item with them, it's a different case than Robinson.
Gaskins?
And Gant, each independently decide this case. I think Gaskins and Gant, in fact, and I know I've got some Gaskins dissenters here, but in my view of the reading of Gaskins and those dissents, the heartburn was about maybe it's reducing searches in the automobile exception, frankly, the ability to search an automobile. But I think the way things have panned out is that those searches have not been restricted whatsoever by Gaskins. In my view, what was odd about Gaskins was the non-application of the automobile exception. I think the state loses nothing by not being able to search vehicles incident to arrest because it can almost always search them under the automobile exception.
Why isn't the justification for officer safety not at issue here when he hands the bag to Tammy and say it has a gun in it? Why can't the officer, before he lets her take the bag, even though Scullark is in handcuffs, why is that not justified?
Because it may be justified under Terry principles, but there just is no reasonable belief that he's in danger in this situation when he has distanced himself. They may be able to.
The defendant, but when he's handing it to the defendant's cohort, why is that not also justified then?
Search incident to arrest. Nothing about search incident to arrest doctrine has anything to do with searches of third parties. The case is cited no case. I've seen no case that says that is part of a search incident to arrest.
Is it hasn't, he's searching it before the third party gets the bag.
So if he takes it before, he still doesn't.
The bag to Tammy, and he says, before you give it to Tammy, I need to search it to make sure there's nothing in it. That could be, that she could use to harm me.
Constitutional search, Your Honor. There is no probable cause to search the bag. There is no, unless they could establish an exigency, something in particular, but officers cannot just open containers because they want to or because they imagine danger.
Gave you is because he is concerned there's something in there. And just because she may have called the cops, I think we all know domestic violence sometimes does a 180 and you no longer have a cooperative witness. She very well could be trying to help her boyfriend. So that example she gave, you're saying that would be an illegal search when the officer says, I'm afraid there might be something in that bag that I'm not going to allow you to just hand it to her. Let me see it. You think that's an illegal search?
He's within his power to tell her to put it down and thereby ensure his safety, no problem. He cannot just open and start looking through things. And I'll clarify, Tammy is not Mr. Scullark's partner by my abbreviation. It doesn't matter, I understand.
Well, no, it doesn't matter if she's the person who called the cops or not. Things go wonky.
And Your Honor, I'm almost out of time. I do want to emphasize the state and Judge Buller in his dissent have suggested that the search at the time of arrest view is the majority view. It's not, and it's not even close. By my review of circuit courts, only one, the First Circuit, has endorsed the time of arrest rule. Every other court, circuit court, which has addressed this post-Gaskins, including the Eighth Circuit case, which Judge Buller cited, expressly adopts a time of search rule. It's just several of them take a very wide view of possibility of access, the kind of thing the state's advocating for today. I think that wide view of possibility access runs straight into the Houdini, Hercules kind of criticisms which Justice Scalia and other judges have made. It has to be reasonably possible that the person can access the bag, that it's possible if they have superhuman strength and are magicians. That's not reasonable. That goes to the same idea in Thornton that we can't rely on unreasonable actions by the officers or belief by the officers to justify a search incident to arrest. Thank you.
Thank you, Your Honor. To pick up where we just left off, I actually think the circuits and other states' experiences are a little bit more diverse than my opponent would suggest. I would refer the court to the First Circuit in Perez from 2023. That was exactly the analysis that the state is proposing here, as well as Bembury from the Kentucky Supreme Court, cited in the dissent. Again, adopting the Robinson rationale for a search of a bag in the defendant's actual possession at the time of arrest. I admire the fidelity of Mr. Irwin's proposed rule, but I think it demonstrates its unreasonableness. It invites gamesmanship by either the defendants or officers or both, and the time of arrest rule for bags attached to a person is clear for application and keeps people safe. Is
immediately accessible. When you say attached to the person, how far does that go?
Facts that would demonstrate that the bag was actually possessed by the person either at the time of arrest or in the immediate proceeding. So the officer saw the person with the bag on their person, set it down for a second, the arrest begins. And I think that Bembury has a great application of that in explaining what the outer contours of that, because once we stray farther from actual possession, the more we're talking about that second Kymel exception for immediate area, and then we would need to show the objective interests are still the two interests are still there objectively. I also would just like to point out that absolutely Gantt and Gaskins are a separate rule. I mean, when we're talking about Kymel and we're talking about Robinson, the search for evidence of arrest is not one of the rationales involved. And yet somehow in the automobile instance, that is a permissible one after Thornton and Gant. Now, this court rejected that in Gaskins, but again, Gaskins was a case about cars. We know this from the text of the opinion. We know it from the special concurrence from Justice Appel, and I think it's fair to say from the dissent as well. Dissents, sorry. Finally,
For you to prevail?
while I might be here another day asking to overrule Gaskins, this day isn't it. And the reason is because Gaskins doesn't apply. And stare decisis would, at least for now, say that that's enough reason to keep it. That said, if the court was to determine that Gaskins does apply, then a harder question is presented. I do believe Gaskins is distinguishable on its facts. Specifically, in Gaskins, there were 2 people present in the vehicle, and both were secured in a law enforcement vehicle at the time of the search of the safe. This case is different. At this point, we are talking about Mr. Scullark here within his wingspan, another officer, Tammy, and another associate. It is on facts distinguishable, even if we were to apply it. I just find that common sense and precedent tell us that this was a reasonable search, and the Court of Appeals applied neither. This court should vacate that opinion and affirm the district court. Thank you.
All right, thank you. The case of State versus Scullark is hereby submitted, and court is adjourned until tomorrow morning. Thank you.